they can repeat the same mistakes, and as we have seen in this instance.
We've also been joined by constitutional law lecturer, Professor Kwaku Ansa-Asare, who's just joined us. Prof, I'm grateful to you for joining us. Now, this is quite an interesting development in our politics and in our how we do practice our democracy. For you, how did this come to you as someone who is versed in the constitutional law of our country?
Hello?
Prof.
Hello, listening to Mr. Ansa-Asare.
Mr. Ansa-Asare.
Yes, please.
Okay. Now, I want to find out from you. You do have, a lot of understanding in terms of, our constitution and how we're governed by these laws. How did this ruling by the Speaker come to you?
Well, thank you very much. I wasn't surprised at all. What we need to understand is that Parliament has its own standing orders. It has its own regulation, its own procedure. And whatever Parliament does in conformity with their laid down procedure cannot be challenged in a court of law. Or that we should expect the Supreme Court to overturn the ruling of the Speaker on a matter that was regularly before the House, that was debated in accordance with the standing orders of the House, that received the Speaker's ruling, communicated in accordance with their standing order 74, rule 1 and 2, and their standing orders came into force this year. Just this year, they made the standing orders for themselves. And my understanding from what the Supreme Court ruled in the J.H. Mensah case was that whatever Parliament does in the exercise of its authority that is lawful cannot be challenged before in a court of law. That's my understanding. And therefore, if the Speaker has spoken and the Speaker said that he has communicated in accordance with the standing practice of the House, and he emphasized that since 1993, this has been their procedure. How does one challenge such practice in the Supreme Court and hope to win?
Okay.
It's not possible. I mean, we are practicing separation of powers. Each arm of government is a domain in its own right. So just as the executive cannot be faulted when they take executorial decisions, so may we also expect that whatever Parliament does in the regular exercise of this jurisdiction cannot be questioned. It is only when they go beyond their powers, when it becomes ultra-virus, it can be questioned. But if it is within, as I'm sure they did this afternoon, it's unfortunate. The majority, try to highlight the fact that they were not giving a hearing. One would therefore say that the rules, the alteram partem rule was brief. But how was it brief? It was debated. Each side was given the opportunity to speak, and then the Speaker made his ruling.
But the former Speaker, Professor Michael Quay, said those who were affected or who were going to be affected by this ruling should have been given a fair hearing. The 4 MPs whose seats have been declared vacant now, that's where the former Speaker was saying those people need to be given a fair hearing. Not necessarily the majority side of the House, but those who are affected.
Fair hearing as to what? As to the fact that they cross carpet, or the fact that there will be consequential nullification of what they did, or if it was validated, then ABC will be the consequences. I don't see the problem here. they were heard, all right. The EC examined their documentation, right? Their internal rules, that's the internal rules of their political parties. And what they should cancel us, not the speaker's ruling. If you cross carpet, you know the consequences, that your seat will be declared vacant. And this is not the first time that the speaker is declaring a seat to be vacant. Mike Okay, I mean when he was speaker, I believe that the same thing happened. The same and it's precedent. So what the House does today, they should be mindful that in 10 years' time, the same thing will play back. So if they expect a certain pattern, then both houses should agree on a certain format. That is, before we declare a seat vacant, we'll invite those directly affected. I cannot say here because I don't have the full details. Whether they were invited or they were not invited. I can't because I don't have those facts. But speaking as a lawyer, I believe that the electoral rules have been met. I don't think that by not calling them for a one-on-one discussion, the rules were breached. Not at all.
So you don't agree with those who argue that the political parties that these MPs belong to should have been the one calling for their seat to be declared vacant and not necessarily a member of parliament asking for?
No, it is an activity that is carried out by the EC and Parliament, so the EC and both houses of Parliament.
All right. So your expectation is that, the Supreme Court will not overturn this ruling by the Speaker?
I don't think so. I can't see how the Supreme Court, can all of a sudden decide to lay down rules and regulations for Parliament. We are practicing separation of powers. The legislature has its own province, the executive has its own province, and then the judiciary. So the judiciary is to interpret the law. It is not to make laws for Parliament or regulate how Parliament goes about its daily parliamentary business. Is none of the function of the Supreme Court or for that matter the judiciary. They don't have that power. If they make any pronouncement that will be inconsistent with the letter and spirit of the Constitution, it will be void ab initio. Simple.